Question number 31. In a Chapter 7 bankruptcy, when does the discharge occur? Discharge occurs usually about 4 months after the date you file the petition with the clerk of the bankruptcy court, and typically 60 days after the end of your 341 meeting. Question 32. How do I get a discharge? Well, unless there is litigation involving objections to the discharge, you automatically receive a discharge. The clerk of the bankruptcy court will mail a copy of the order of discharge to you and to all creditors and to the United States trustee and your individual trustee in your case, and the trustee's attorney if there is one. Question 33. Does the discharge order name the creditors? The answer is the final order of discharge is not specific as to those debts determined by the court to be non-dischargeable, i.e. not covered by the discharge. The notice informs creditors generally that the debts owed to them have been discharged and that they should not attempt any further collection. Question 34. Will they keep hounding me after I get the discharge? Well, they are informed in the discharge order that continuing collection efforts could subject them to punishment for contempt of court. Any inadvertent failure on the part of the clerk to send the debtor or any creditor a copy of the discharge order promptly within the time required by the rules does not affect the validity of the order granting the discharge. So the discharge is good whether there's notice of it or not. Question 35. How long should I keep my discharge papers? Since a judgment is generally good for up to 20 years, you should keep your discharge notice in a safe place and a secure location for that time period. It is possible that a creditor could have sold a judgment that has been discharged to another creditor, and without knowing that it's discharged, you could be contacted by the next creditor in line attempting to collect the debt, and that could happen years later. You can then simply send them a copy of the discharge notice to stop their collection efforts. Question number 36. Will all my debts be discharged? Well, no, not necessarily. Not all debts are dischargeable. The most common debts that are not discharged are alimony, child support, injuries to individuals based on willful acts, debts for death or personal injury caused by the debtor's operation of a motor vehicle while the debtor was intoxicated from alcohol or other substances, and debts for criminal restitution. Question number 37. Can creditors object to the discharge of a debt? In Chapter 7 cases, an objection to the debtor's discharge may be filed by a creditor, by the trustee, in your case, or by the United States trustee. Creditors receive a notice shortly after the case is filed, and that notice sets forth important information, including any deadline for objecting to the discharge. Question 38. How does a creditor object if they want to? Well, a creditor who desires to object to the debtor's discharge must do so by filing a complaint in the bankruptcy court before the deadline set out in the notice. Filing of a complaint starts a lawsuit referred to in bankruptcy as an adversary proceeding. Question 39. What would be the legal basis for an objection to discharge? A Chapter 7 discharge may be denied for any of the reasons described in Section 727A of the Bankruptcy Code, including the transfer or concealment of books or records, perjury and other fraudulent acts, failure to account for the loss of assets, violation of a court order, or an earlier discharge of a Chapter 7 or 11 case commenced within 6 years before the date that the petition